for inclusion. This is a new motion.
No. Yes.
May I be permitted to mention this matter? This matter was supposed to be listed on 20th of April. This is
20th of February.
20th of April.
Yes.
This is a restoration application. Let it be included, Lordship.
Who directed to appear on the 20th?
In the filing department, date was given as 20th April.
Maybe. It will appear in its usual course. Today is not the day for mentioning for inclusion. Yes. Call the list, please. Not today.
I'm for the petitioner, madam. But I appear for the respondent. On the last occasion, I almost concluded, my lord, my submission. My lord, may I just recapitulate the facts? My lord, the Coal India, my lord, initiated a selection process, my lord, to promote non-executive officers from non-executive cadre to executive cadre. 2015, it was initiated, written examination was held, and then, my lord, it was cancelled. They found some procedural impropriety, so it was cancelled. Then, my lord, they once again initiated the selection process. The petitioners, my lord, they participated in the written examination. A list was published. They were, my lord, within that list, and then they participated in the answer script was uploaded on the official website. And thereafter, my lord, they appeared before the interview board. Then, my lord, the key answers were not published in terms of the timeline, my lord, submitted before the Honorable Court, my lord, at Nagpur. And thereafter, my lord, they, my lord, uploaded the selected candidate, names of the selected candidates of 109 candidates. And after, my lord, uploading those 109 selected candidates, my lord, after a lapse of almost 6 months, my lord, they uploaded the key answers, changing the initial key answers, and, my lord, in that key answers, my lord, they also informed that they have awarded 19 marks to all candidates, those who have attempted or those who have not attempted those questions. Irrespective of the fact whether attempted or not, they awarded 19 marks. Now, my lord, immediately thereafter, my lord, they submitted a representation for inquiry and then filed this writ petition, my lord. Now, why these 19 marks were awarded to all? My lord, the Coal India in their affidavit has disclosed in paragraph 10, my lord, kindly, my lord, take the affidavit in opposition filed by Coal India Limited, my lord, page 17, paragraph 10, my lord.
Yes.
That with regard to statements made in paragraph 11 and 12 of the said petition, this deponent states that those are matters of record. However, the writ petitioners observed that the question and answers are correct as such. They did not raise any objection, but fact remains that several candidates raised objection and the agency engaged for the purpose found that out of 200 questions given to the candidates in the CBT of welfare or personal discipline, there were 19 questions which had discrepancies, such as few questions are out of syllabus, wrong questions, kindly consider this, wrong questions or answers, wrong questions or wrong answers, etc. As such, agency had given full marks against those 19 questions to all the candidates of welfare or personal discipline who appeared in the said examination, whether they attempted those or not, including the petitioners. Now, my lord, kindly visualize a situation, my lord. Suppose a candidate, my lord, who had submitted a blank answer script without attempting any question, he will also, by this decision, will get 19 marks. In any event, my lord, this is the stand taken by the CIL. My lord, I shall briefly demonstrate that this is absolutely incorrect, that all the questions and the answers were correct. And, my lord, I shall show from the writ petition itself, my lord, with supporting documents. My lord, kindly consider, if your lordship kindly keep the first volume and the second volume side by side, my lord, it will be easier for your lordship. My lord, page 145, which is at volume 2 of the writ petition.
Yes.
Well, there is a chart. These are the disputed 19 questions in respect of which, my lord, the Coal India decided to award 19 marks to all candidates. My lord, kindly see the left hand side, there is a question ID. Last 4 digit is 2321. Now, this 2321 question, your lordship will find at page 50 of the writ petition, my lord, volume 1.
Last question is
No, my lord, this question
Eight.
ID 2752282321. Left hand side one, the question ID was
left hand
given.
side.
Malad,
221, the first one. First
the
one.
first box.
Yes,
2321.
yes. Hmm.
This is the question ID.
Yes.
So the last 4 digit is 2321.
Yes.
I'm not Malad, reading the entire ID.
Mhm.
Kindly consider page 50 of the writ petition, Malad, that is in the first volume.
Yes.
Page 50, Malad, question number 5, your lordship will find right hand side box at the top, question ID 2321, 275222321.
Hmm.
So kindly, Malad, may I just place the question? What could be the approximate total coal production of CIL in the year 2020? One of the following is the correct answer. 300 million tons, 100 million tons, 400 million tons, and 600 million tons. Now, Malad, kindly consider page 169 of the second volume. The correct answer is 600 million tons.
Hmm.
Kindly see page 169.
Yes.
My lord, this is page 169 is a document, my lord, issued by the Coal India Limited, the first page. Then the operational statistics in the next second page, this next page, my lord, page 170. My lord, kindly see the second column, 2020.
Hmm.
Total production 602.138.
Hmm.
My lord, fourth column.
Hmm. Hmm.
Therefore, my lord, the approximate total coal production in the year 2020, the correct answer should be 600 million tons.
Hmm.
The actual was 602.138.
Hmm.
Then, my lord, the second question is at page 167. I'm sorry, page 49 of first volume.
Hmm.
Question number 2. ID number 2328. Under the coal mines regulation, my lord, question number 2.
Hmm.
Third question. Under the coal mines regulation 2017, coal does not include one of the following. There are 4 options: lignite, bituminous coal, anthracite, and methane. Now, your lordship will find the correct answer, page 167 of first volume. I'm sorry, in the second volume, 167.
Yes. This answer or this question was found to have discrepancy. And
Yes,
that is the
methane,
reason.
1000 years, methane is a gas.
Yes.
And my lord, 1000 years ago, my lord, it was a gas. After 1000 years, it will be a gas. It cannot, it's a basically byproduct of a qualification process. How can it be a coal?
Huh.
However, my lord, I shall from documents I shall show page 167. Even a class 8-9 students, my lord, will know methane is a gas. Kindly see, my lord, page 167. Definition 2B, my lord. Kindly consider definition 2B. Page 167.
Yes.
Abandoned mine methane means a natural gas recovered from abandoned coal mines or part thereof. Therefore, methane is a gas. The correct answer was 4. Rightly, it was, my lord, ticked. However, my lord, it was said that this answer is incorrect. Now, the third question is, my lord, your lordship will find at page 53, my lord, from the first volume. The question ID is 2347. That is, my lord, question number 7.
No, whatever, without going into all this, what is the justification that is there in the AO to give 19 marks to all the candidates?
That is exactly, my lord, my point. This is absolutely unreasonable. First. Second, my lord, this is very common in any, my lord, selection process, that maybe one or two questions can be disputed or some answers are incorrect. In that event, my lord, the procedure is, my lord, there are judgments. I can cite those judgments if your lordship wants to see that those questions should be deleted from the entire selection process. The disputed questions should be deleted. Suppose there are 100 questions. Out of these 100 questions, 5 are disputed. Then, my lord, 5 numbers will be, those 5 questions will be deleted. Remaining 95, and these 5 numbers will be, my lord, on pro rata basis, this will be given over this 95. That is this procedure. This was adopted by UPSC, this was adopted by other expert bodies, but that is not the issue here. Here, my lord, all these answers are correct. My lord, I shall show 19 questions and with supporting documents. All the questions, there is no ambiguity, there is no discrepancy. These are all, my lord, they have changed the game. There was no, my lord, procedural aspect or indication that they will in this way change this.
And all the questions relating to this coal.
Yes, and some, my lord, legal questions from, my lord, say, my lord, labor related question, labor law related question.
All right.
My lord, my lord, I have prepared a chart. I can, my lord, hand over this because all these, my lord, I can demonstrate, my lord, from the writ petitions that all the questions, my lord, your lordship, kindly take any question, I shall satisfy your lordship. And there cannot be any ambiguity. There cannot be any discrepancy. Any question, my lord, your lordship, ask me any question out of this 19. I shall satisfy your lordship here and now.
All right.
My lord, let us, my lord, take any question. Let us, my lord, take question number 14, my lord. My lord, for my satisfaction, my lord, your lordship, kindly take up question number 14.
NCWA,
Yes.
sick leave.
No, my lord, your lordship will find this question at page 80, my lord.
80.
80.
All right.
This is, my lord, the ID is 2821.
Mm-hmm.
As per the National Coal Wage Agreement 10, sick leave with full pay can be accumulated up to blank days prospectively. Now, my lord, your lordship will find, my lord, the answer is at page 161, the second one.
All right, page 80, I can see chosen option is 2. Is this your answer?
No, this is the answer, my lord, given by
Answer
the
key.
CIL initially.
Answer key.
Answer key.
All right.
My answer is, my lord, the right hand side box, chosen option 2. I have given the correct answer.
All right.
Page, my lord, 180. I'm sorry, no, this is not the correct 161, my lord. 161. My lord, let me read once again, my lord. As per the National Coal Wage Agreement 10, sick leave with full pay can be accumulated up to blank days prospectively. Kindly consider, my lord, page 161, 6.5 relates to sick leave and special leave. Then, my lord, 6.5.1, the existing provision relating to sick leave of 15 days with full pay in a calendar year will continue. Sick leave with full pay will accumulate up to 120 days prospectively. Therefore, the correct answer is 120 days. This cannot be changed. Even after 5 years, unless it is amended, my lord, this will continue. Therefore, my lord, in this way, my lord, the Coal India, my lord, accommodated, or, my lord, I will say, my lord, they have given undue advantage. That too on the basis of the suggestions given by, my lord, some of the candidates. My lord, they have given undue advantage to some of the candidates, and they, my lord, in this way accommodated their favored candidates. Now, my lord, the second issue is, my lord, this was never indicated, my lord, or this decision that they will give 19 marks to all candidates. And kindly consider 19 marks, my lord, make a lot of difference, my lord. It is not about 1 or 2. In a competitive examination, my lord, the fairness will go. If there is a, my lord, discrepancy with regard to 19 marks, they should have cancelled the entire selection process.
Yes.
Now, my lord, these are, my lord, the facts, my lord. Now, my first, my lord, submission before your lordship is that today, admittedly, the selected candidates are not before your lordship. Now, my lord, I am not saying that your lordship cancel their selection, my lord, immediately without affording any opportunity to them. But in a case like this, my lord, the Supreme Court says that even after, my lord, participating in a selection process, my lord, if, my lord, it has come to the knowledge of a candidate that there are some illegalities, my lord, and the provisions of Article 16 has been violated, then, my lord, he is not stopped to file a writ petition.
This is a promotional policy or examination of which year?
My lord, initially it was initiated in 2015, then the examination was held in 2021, the second examination. It was held in
2020.
31st July 2021, re-examination was held. My lord, the first judgment, my lord, I shall cite is I'm correct. My lord, this is Rajesh Kumar Gupta and others versus State of UP, reported in 2005, Volume 5, SCC 172. My lord, two issues were decided by the Honorable Supreme Court, whether here, my lord, the selected candidates were not made party to the proceeding, and second, my lord, whether after it is, my lord, against the principles of Madan Lal, my lord, whether after, my lord, participating in a selection process, whether
Unsuccessful candidates,
yes,
whether they can
Rajpur
come.
versus there was one judgment, my lord, 1997 9 SCC, although this was again considered. My lord, kindly take, my lord, paragraph 8. My lord, the broad grounds of challenge before the learned single judge were as follows. 1. The preparation of merit list district-wise were arbitrary and violative of Article 14, 15, 16 and 21 of the Constitution. Then, my lord, paragraph 9. The learned single judge overruled the objection that having taken their chance under the rules, the candidates who had failed were not entitled to challenge the selection process. This was overruled by the single judge.
But you are not challenging the selection process per se.
No, I am not challenging the selection process. I am only saying, my lord, I shall show one judgment. The Supreme Court says that if it is possible, my lord, to segregate the tainted and untainted, I will not say they are tainted, but they were given
Procedure
undue
adopted.
advantage. Yes,
Procedure adopted
it
was
can be,
not proper.
it can be redrawn, my lord.
Hmm.
Then paragraph 10. The state of UP impugned the judgment of the learned single judge by its special appeal before the division bench of the High Court. Some of the candidates, that means the selected candidates, in the selection also filed special leave before the division bench. The division bench heard all the special appeals together and disposed of them by the impugned judgment, which upheld the judgment of the learned single judge with a slight modification. Then paragraph 11. The division bench raised the following points which arose for its determination. 1. Whether the absence of the selected candidates having been impleaded by the writ petitioners, the writ petitions are maintainable. 2. Whether the writ petitioners having applied for special BTC training course and having failed to get their name in the merit list are stopped from challenging the advertisement and selection made pursuant thereto. Well, the answer is in paragraph 12. Well, 6 lines. The sentence starts with relying on the judgment. Relying on the judgment of this court in I.J. Divakar versus Government of AP and Shankarshan Das versus Union of India, and the state made by the Chief Standing Counsel on behalf of the state made at the bar, the division bench held that even though the candidates whose names appeared in the select list were not made parties to the writ petitions, the writ petitions could not be summarily dismissed on the said ground. We are inclined to agree with this finding of the division bench, which is supported by the authority of the Constitution bench in Shankarshan Das versus Union of India and several other judgment of this court. Malad, kindly pause here for a moment. Malad, here the persons who were selected is slightly better on a better footing because they were selected candidates, they were not appointed. And here, Malad, those were appointed, some right has already been accrued. But I'm saying that I'm not saying that immediately their selection should be cancelled. Then paragraph 13, my lord, the sentence starts with 6 line, consequently, my lord. Consequently, no candidate had any occasion to protest since the criteria was abruptly changed by the state government. Thus, the division bench overruled the objection to the maintainability of the writ petitions by taking the view that there was no question of estoppel and the candidates who had applied and were not selected could not be said to be stopped from challenging the process of selection. nor could there be any plea of promissory estoppel invoked by the writ petitioners, as nothing was established to show that they had altered their position to their detriment by applying pursuant to the advertisement. In our view, the finding of the division bench on this point is justified. Therefore, my lord, one can challenge this, my lord, because the knowledge, we gathered this information, my lord, on a subsequent date, that 19 marks were given to all the candidates after appointment, my lord. Now, my lord, the next issue is, my lord, that this criteria, it was not disclosed, my lord, beforehand, and, my lord, it was challenged subsequently whether this is permissible or not.
Which criteria?
My lord, that they will award, if there is any discrepancy, they will award any marks to all candidates.
All right.
My lord, this is reported in 2011 6 SCC 605.
2011?
2011 6 SCC, page 605. My lord, paragraph 40. Only 2 lines, my lord. Paragraph 40, my lord, last 2 lines.
Yes.
Well, the last 2 lines. Had the appellant disclosed the method of evaluation, the respondents may have challenged the same before participating in the selection process. This is a settled issue, my lord. My lord, then, my lord, your lordship knows, my lord, in service jurisprudence, my lord, it is well settled, my lord, that one cannot, my lord, change the rule of game once it commences, my lord. This is a very well settled, my lord. Your lordship kindly consider here, my lord, why I am placing this, my lord, that today, my lord, there was no decision on the part of the either agency who conducted the selection process or on the part of the CIL. I do not know whether this was, my lord, referred to the CIL or the appropriate authority of the CIL, that we are adopting this kind of yes. Therefore, they have abruptly changed everything. And this is, my lord, I shall show, my lord, there is no judgment, my lord. I have searched a lot, my lord. I have not found any judgment in support of their conduct.
In the opposition, CIL disclosed that this was done taking their
There is
views,
nothing. How they have adopted this, whether it was referred to CIL or not, whether CIL approved it or not, whether they have taken any, my lord, suggestion from expert body or not. Because I have, there are judgments that UPSC, my lord, in a situation like this, my lord, they had taken suggestions from expert body, and that was approved by the Honorable Supreme Court. That is, and what I have said, that if it is found that, say, 4 or 5, not 19, 4 or 5 questions out of, say, 200 questions are disputed, then, my lord, the Supreme Court observed that very well, you deduct those 4 marks, and these 4 marks will be redistributed amongst the correct on a pro rata basis, my lord. So that was the issue, my lord. Here, my lord, they have adopted a new procedure. Now, my lord, this rules of game cannot be changed afterwards. This is reported in my lord, 2008 3 SCC, page 512. K. Monjusri, this is a, my lord, celebrated judgment, my lord. K. Monjusri versus State of Andhra Pradesh. 2008 volume 3 SCC, page 512, para 27. My lord, para 27, the sentence, my lord, at the end of that paragraph, your lordship will find almost 8 lines from the end.
Yes.
Well, the sentence starts with therefore.
Yes.
Therefore, introduction of the requirement of minimum marks for interview after the entire selection process consisting of written examination and interview was completed would amount to changing the rules of the game after the game was played, which is clearly impermissible. Now, my lord, this was once again followed, and, my lord, considered and followed, my lord, in 2025 2 SCC, page 1. My lord, paragraph, I'm sorry, paragraph 65, my lord. My lord, paragraph 65, 65.2. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement which is not contrary to the extant rules so permit. Even if such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Now, my lord, only one last judgment, my lord, on the issue. It is reported in 1983 4 SCC 309. Here, my lord, a peculiar issue was considered by the Honorable Supreme Court, that the examiner says that out of 4 questions, A is correct. But the student, my lord, who appeared in the selection process said that no, A is not correct, B is correct. The matter was taken up by the Honorable Supreme Court. The Honorable Supreme Court, my lord, considered all textbooks and found that no, the student was right. So on the basis of those issues, my lord, the Supreme Court, my lord, was pleased to observe that no, the marks should be given in spite of the fact that the authority or the examiner is saying that A is correct, but it appears from records that B is correct. Therefore, full marks should be given to the student. This is reported in 1983 4 SCC, page 309. My lord, kindly, the second page, my lord, kindly consider the first paragraph. My lord, the issue was framed. These appeals raise a somewhat awkward question if a paper setter commits an error while indicating the correct answer to a question set by him. Can the students who answer that question correctly be failed for the reason that though their answer is correct, it does not accord with the answer supplied by the paper setter to the university as the correct answer? Now, my lord, your lordship will find that Supreme Court decided the issue in paragraph 18 and 20. Paragraph 18, my lord, kindly consider page 317, my lord, of paragraph 18. My lord, 8th line, my lord, the sentence starts with that kind of system. That kind of system of examination involves merely the tick marking of the correct answer. It leaves no scope for reasoning or argument. The answer is yes or no. That is why the question have to be clear and unequivocal. Lastly, if the attention of the university is drawn to any defect in a key answer or any ambiguity in a question set in the examination, prompt and timely decision must be taken by the university to declare that the suspect question will be excluded from the paper and no marks assigned to it. Here the Supreme Court says no marks should be given to anyone. Then paragraph 20, my lord, in the middle your lordship will find the sentence starts with if the key answer. If the key answer was not wrong, as it has turned out to be, they would have succeeded in getting admission. In view of the findings of the High Court, the question naturally arose as to how the marks were to be allotted to the respondents for the 3 questions answered by them and which were wrongly assessed by the university. The High Court has held that the respondents would be entitled to be given 3 marks for each of the questions correctly ticked by them, and in addition they would be entitled to 1 mark for those very questions, since 1 mark was deducted from the total for each of the questions wrongly answered by them. Putting it briefly, such of the respondents as are found to have attempted the 3 questions or any of them would be entitled to an addition of 4 marks per question. Then, my lord, the last sentence, accordingly we confirm the directions given by the High Court in regard to the reassessment of the particular questions and the admission of the respondents to the MBBS course. Now, my lord, here, my lord, there is one fact is very clear, that all these questions, there is no ambiguity with regard to these 19 questions. All the questions are clear. Initially, my lord, the Coal India, when, my lord, they uploaded the correct answers, my lord, which I have annexed, my lord, all these answers were correct. And there are supporting documents which I have also annexed. And, my lord, the Coal India initially correctly assessed this. But thereafter they changed the game. Thereafter, my lord, they my lord, without any basis, my lord, they said or declared, my lord, that this 19 question suffers from ambiguity. Therefore, 19 marks should be given to all candidates, whether they have attempted or not. Now, my lord, my prayer is, my lord, before your lordship, if, my lord, I have satisfied or made out a case, my lord, prima facie, my lord, kindly, my lord, consider, my lord, here, my lord, your lordship will find prayer E. Kindly consider this, my lord. Page 22, my lord, volume 1. A writ in the nature of mandamus commanding the respondent authority to constitute an independent committee on the issue of wrong question and or answers to evaluate the correct position. My lord, today, admittedly, my lord, the candidates who were selected, my lord, are not before your lordship. Now, they have accrued rights. There is no doubt about this. Now, my lord, this issue, my lord, whether these 19 questions or answers are correct or not within syllabus or not, or the other issues, my lord, this can be looked into, my lord, by an independent body. I will request your lordship, my lord, to either, my lord, constitute a committee, my lord, headed by any retired judge or academician, any independent body, my lord, and, my lord, let that body or that, my lord, authority, my lord, consider it after giving opportunity to one or two representative from the unsuccessful candidates like the petitioner, and one or two, my lord, from the persons, my lord, who have been selected. My lord. Here, Coal India should take a neutral position, my lord. They should be, my lord, taken. I do not know whether their presence is required or not. That I leave it to your lordship. Now, after, my lord, if it is found by the committee or the officer, my lord, that no, my lord, procedural impropriety has been committed, my lord, then, my lord, your lordship can always direct, my lord, that the select list should be redrawn, my lord, and successful candidates, my lord, may be appointed.
Was there any syllabus?
There was a
Was-
syllabus.
Yes.
I have, my lord, I have indicated, my lord, in my petition. Your lordship will find, my lord, in the opposition, my lord, also your lordship will find this.
And the entire examination was outsourced.
Yes, entire selection process, including, it is my apprehension, only Coal India can answer this, including, my lord, preparation of panel, and, my lord, they, my lord, again, my lord, altered the position without, I think, my lord, without taking any permission from the Coal India, whether they have taken it or not, whether the entire actions has been approved by the Coal India or not, that has not been disclosed. So everything has been done, my lord, by a third party, by an outsider, by an agency, and it is not an agency like UPSC or PSC. It is not a statutory agency. It's a third party, a private organization. So how, my lord, they have reshuffled, my lord, the entire initial list without extending any opportunity, and that too, the final key list were uploaded after selection process, after their appointment. This is a, my lord, illegality, my lord, it's a glaring illegality, my lord. My lord, your lordship will find page 30 of the opposition, my lord. Yes. This is dated 21st July 2021. Paper 1 and paper 2 of the computer-based test for the re-examination of eligible departmental candidates will be as per the syllabus already uploaded in the Coal India website, link of which, I'm sorry.
This opposition is unpaginated, is not paginated. Please paginate it fast. Dadinto. Yes, read out.
My lord, this is dated 21st July 2021, just prior to the selection. Yes, that's just prior to this selection process. 31st July, the written examination was held. So Coal India uploaded it on their website on 21st July 2021. Paper 1 and paper 2 of the computer-based test for the re-examination of eligible departmental candidates will be as per the syllabus already uploaded in the Coal India website, link of which is as under then a link was given. Departmental candidates who are appearing for computer-based test for promotion or selection from non-executive to executive cadre may take note of it so that there is no confusion regarding syllabus of paper 1 and paper 2. Now, my lord, here, my lord, there is one thing which is, my lord, very peculiar, that the agency, my lord, obtained suggestions or objections from the candidates, which is, my lord, unheard of normally. One, my lord, of their own can sometime, my lord, give some objection or suggestion, but it is a matter of, my lord, their procedure that they will collect objections after the selection process. This will, my lord, enlarge the scope of nepotism or, my lord, the arbitrariness. By this way, my lord, they can always accommodate any candidate. And once again, my lord, I will, for the sake of repetition, I am, my lord, once again, I will submit that 19 marks will make a lot of difference in a selection process.
All right.
My lord, these are my submissions.
Yes, CIL.
I thought one identical matter, my lord, by other candidates, my lord. That is, my lord, WPO number 1386 of 2023.
It was taken up, they didn't appear.
It was taken up, but they didn't appear, so it was adjourned. I propose, my lord, that that matter also may be taken because that is the same selection process.
All right.
And there, my lord, same advocate, and my lord, the exhaustive, my lord, reason why it was done, it was not done, everything was
In
given.
that matter,
My lord.
are you aware?
Yes, yes,
Yes, my lord, that was taken up for consideration, but there is one, I will say in this way, there, my lord, the petitioner also raised some suggestions. They
That's
raised some
why-
suggestions. Here, my lord, the Coal India may say that they have raised suggestions, though therefore they are stopped to raise this question. Here, my lord, these petitioners has not raised any suggestions.
That apart, it is of the same, arises out of the
Fine.
same
Same selection process. Same
And
selection process.
1024, my lord, candidates raised objection. He has not disclosed that.
Maybe, but then 1024 candidates raised
My
objection.
lord, raised objection.
All right. That matter, it has gone out of the list.
Gone out of the list.
All right, you give the number, it will appear together.
My lord. WPO 1386 of 2023. Abhishek Sharma and others. Versus Union Appointment and others.
What is your justification in granting marks to candidates
My lord.
who did not attempt the question?
My lord, actually, the uniform policy was taken, my lord, because this petitioner attempted, my lord, he got 14 marks out of 19. And the second petitioner, my lord, what my learned friend has not submitted before your lordship, that he is not contesting this writ petition. Because in the other bench, my lord, it was told that the second petitioner is retiring from this petition. So, my lord, he argued on behalf of both of them. And, my lord, since, my lord, 124 objections were raised, and, my lord, it is very much there within their knowledge that, my lord, the objections, that is page 45, my lord. Page
No,
45.
just tell me one thing.
My lord.
Somebody who answered a question which you later on found to be having discrepancy or incorrect, or there was some problem, you award mark to that candidate is all right. But somebody who has not attempted that question, if you award mark,
My lord,
because it's
there
out
are-
of syllabus.
because that was out of syllabus, because the initial, my lord, selection process was, my lord, conducted as back as in 2015. Thereafter, my lord, there was, my lord, change of syllabus, and that's why, my lord, 124 objections were raised, that these were not in the syllabus of 2015. So how can that be taken into account? So that is why, my lord, the expert agency decided, my lord, to give uniform marks 19 to each and every candidate. my lord, that would not defer his position because he was out of the zone of consideration. Though
Why out of the zone of consideration?
his name, my lord, appears to be, my lord, as serial number 78 and 87. But, my lord, that is alphabetically done. They were under the impression that they are, my lord, in the select list of 79 and 87, but that is not there. The heading of that, my lord, list will indicate that this was prepared as alphabetically,
Very well.
my lord.
But then
After that, he entered.
this I cannot understand. If somebody has not answered a question, why will marks be allotted to
My
him?
lord, that was not checked by the expert agency. That, my lord, if your lordship bring the record of the case, my lord, there, my lord, we have disclosed each and everything, my lord. That is, if your lordship kindly see that.
এটা তো objection raised. The why it was ওটা দেখাবেন? Why it was out of syllabus?
Yeah.
এরকম যা যা question উনি বললেন না সব cover যাবে।
My lord, kindly see the other affidavit in opposition where, my lord, it has been specifically disclosed
Hmm.
why it was out of syllabus, these 19 questions.
All out of syllabus.
Some were wrong, some were, my lord, out of syllabus,
14 out of
14 was out of syllabus, and rest, my lord, are wrong, and there are discrepancies. That's why 124 objections were raised by the participating candidates, and, my lord, then the decision was taken that,
Who took the decision?
my lord, the expert agency, my lord.
subject.
Was it in consultation with CIL?
It's a PSU
Was it within your knowledge
My lord,
that
it is-
this system is being adopted?
That was not, my lord. It was because since the entire autonomy was given to them, my lord.
So they
So-
took whatever decision they took.
Not the decision, my lord. I will satisfy your lordship that there is nothing wrong, and, my lord, they are now advancing the argument that rule of the game was changed, but that has not been pleaded anywhere, your lordship, with supportive evidence, because the only, my lord, plea was that when we have taken the, my lord, point of maintainability at the first instance, that whether an unsuccessful candidate, my lord, after having participated in the, my lord, the selection process without demur, my lord, can challenge the selection process. Here, my lord, they have, my lord, cited my lord, the prayer only concentrated to that, but their first prayer is to cancel the selection process. So, my lord, they knew that the selection process was over. 109 candidates were promoted. Thereafter, after 6 months, they came before your lordships to file the writ petition, only to stall the, my lord, entire promotional, my lord, benefit to the successful candidates. Here, my lord, your lordship would found that not a single, my lord, though they knew that, if your lordship kindly see page 45 for a moment, he has not disclosed that thing, that, my lord, this was intimated to each and every, my lord, this notice, page 45. Kindly see for a moment. And it was in the
writ petition.
writ petition, my lord. It is in their writ petition. My lord, last paragraph, if your lordship kindly see. The response query management inviting comments, objections, if any, from the candidates who appeared in the computer-based online tests CET held on 11/7/2021 regarding questions, answers in the computer-based online test CBT for departmental candidates for promotion selection from non-executive to executive cadre shall be made operational on official website of Coal India Limited with effect from 4/8 to 8/8/2021. The link for objection management can be accessed on CIL website as well as on the individual login portal of the candidate, and it will be hosted for the duration as stipulated above only. Objections through any other mode and beyond the scheduled time period will not be entertained. My lord,
Admit card also it was there.
in the admit card, my lord, in the admit card, it was also there.
19.
In in my lord, clause 19, if your lordship kindly see that they have also suppressed. This was
What?
that if any objections, my lord, that I am reading any query or objection in respect of any questions and its answer, if any, is to be submitted only through online objection link at CIL website only. The link will start after 3 days of the conduct of CBT and it will be operational for a period of 5 days only. Objections, complaint related to question answer received through any other mode or communicatory channel will not be entertained under any circumstances. Non-receipt of objection within stipulated period will not have any right for any future legal claim in any court of law or any forum and for the revaluation of latter stage of selection process. This was within the my lord, terms and conditions. They are, my lord, making a new case that rule of the game was changed. That is not that. It is very much, my lord, in the notice. It was very much in the website. It was within the.
Was it disclosed that if there any wrong answer is found, then marks will be allotted to each and every candidate in the examination? Was this ever disclosed?
My lord, this was done taking into account of, my lord, the objections and, my lord, comparing with the answers.
Yes, you took into consideration the
No,
objections.
my lord, this
You
was done.
found that this was
That-
erroneous.
My lord,
right?
this was
How
not
do
announced.
you-
This was not announced that if any objection was found, that the marks should be given to the candidate who raised the objection if it is found that it is out of
Not
syllabus.
who raised the objection, but who attempted the question.
My lord, that is why it is uniformly done, so that no one can dispute about that.
It is not so. You say it is uniform, but it cannot be uniform. I tell you why. Suppose it is 100-mark examination,
My lord.
and out of 100 mark, 10 is wrong. A candidate who appearing in an examination gets to see that this is not the proper question. I do not think I will not answer. That candidate does not answer that and answer some other questions, right? And somebody who answers that gets a mark extra,
My lord.
and somebody who has not answered doesn't get any mark. So what happens? Who gave the correct answers get the marks, and who did not answer, he also gets the mark.
Since, my lord, the policy was, since it was detected that it was out of syllabus, since it was detected that there was discrepancy and also the wrong, my lord, answer script, answer key, that is why, my lord, a uniform decision was taken that so far those 19 questions are concerned, my lord, marks should be given to each and every candidate, my lord, 19 marks.
Not 19.
There was a negative
Not
marking.
19 extra marks. That is
There
19
was a
marks.
negative marking.
No, my lord, there was no
No
negative
negative
marking.
marking.
No negative marking was there.
All right.
So, my lord, there is complete transparency in the, my lord, process. My lord, what they have argued, they have suppressed these these notice as well as the, my lord, the stipulation in the admit card. And if it is there, his whole contention, my lord, whole argument, my lord, based on, my lord, erroneous, my lord, my lord, documents, because neither he has, my lord, produced before your lordship a scrap of paper, because this is an omnibus and evasive allegations, because he said that it is his suspicion. My lord, if in the, my lord, in his writ petition, my lord, he has said that because of his suspicion, my lord, he has filed this writ petition. My lord, suspicion, whatever the, my lord, grave it is, it cannot take the place of proof. And, my lord, only on the basis of assumption and presumption, my lord, an unsuccessful candidate cannot challenge the whole selection process. And, my lord, here they have not only, my lord, made a representation to the chairman, my lord, CIL, but they have prayed for, my lord, an investigation by CID West Bengal. My lord, the candidate who has not come within the zone of consideration, who was in the merit list and was given the opportunity to my lord, appear before the interview and who became unsuccessful. Then, my lord, after, my lord, getting that, my lord, that he could not come within the, my lord, the zone of consideration. So, my lord, he belatedly thought that, my lord, he should challenge and, my lord, stall the entire process. My lord, my first submission, if your lordship take up this matter along with that,
All right, give the number. It
my
will
lord,
appear
it
along
would be
with that.
better, my lord.
All right. Please come.
My lord, may I just only one thing, my lord, my learned senior friend has said that I have suppressed page 40. Page 40
No, it's
is the
annexed.
text of the writ
Yes,
petition.
yes, it's annexed.
Kindly consider my list
No,
of
you have
dates.
not
Yes,
referred.
yes.
You have not referred.
In the list of dates I have referred, and my lord,
Yes, yes, yes. Learned advocate representing the petitioners concludes argument. Stop. Learned advocate representing CIL submits that a separate writ petition challenging the same promotional process is pending consideration before this court. Stop. Let the writ petition being number such and such appear along with this writ petition on next Thursday. 30th, next Thursday,
first, grateful, man.
30th. What happened?
And my lord, the petitioner number 1, with the leave of the court, my lord, participated in the next selection process. And my lord, so far I came to know, my lord, it is reported that he has been shortlisted and he will get the promotion.
So that is without prejudice, my lord. The court granted us liberty to
Yes,
participate in a subsequent selection. That has nothing to do with this.
Grateful, your lords.
Your other side is not here, I can see.
Let's take it.
Just 1 minute. Mr. Shumon Bey, are you there online? I was told that a final order has been passed in this matter.
But what I did, blood, I have filed
a separate writ petition. So this becomes infructuous.
and take it up together, blood, because I'll ultimately demonstrate that they are acting in violation of the order passed in the first matter. I'll take it up tomorrow.
Mr. Shumon Dey. Not this week.
I'll take it up tomorrow, if possible.
Tomorrow, if he is there, I can take it because I can see him there, but then
as far as
not
my instruction,
responding.
Mr. Shamrat
No, my lord, I'm praying for not today, my lord.
Tomorrow, are you coming?
Tomorrow, my lord, I'll be coming.
All right, then not today.
Not today.
1 and 2 both?
One, only one. I have received instruction, but I believe that will cover the entire case. They have already taken a decision, and perhaps, my lord, subject to correction, they have already communicated to the petitioner also.
Right. The second writ petition has been filed challenging the reasoned order which has been taken in response to item
Yes.
number 1. So
That
are
I
you
shall
taking
take
item?
instruction, my lord. I
Please.
shall take instruction on that also, that
You,
whether I
if
have been.
copy has not been received by him, you inquire who is appearing
Now,
so that he also gets to know.
yes.
Please check up who is there for the respondents in item number 2 also. You get in
Shubham,
touch.
I'll be sending a soft copy to you.
See what can be done. All right, 3. Yes.
Matter relates to election duty.
Election duty? Yes.
A like, teacher of a polytechnic college.
Teacher in a college.
Polytechnic college.
Why will it come here? Why will it not
It's
go
a
before the
government employee.
education?
Government employee.
Maybe.
The formulate
Education service will it not go?
it's not really service.
Residuary. It's called residuary.
Either residuary or this court.
No,
Because all tribunal matters, we are approaching this court.
Should it be a tribunal matter? They are they employees of the government?
Partly related to this,
Where are they serving?
that in the government polytechnic college.
Government Polytechnic College.
Yes.
Then it should be residuary possibly.
But some matters we are moving to the residuary court.
Yes, you go before the residuary court. Let the matter be released from the list for want of determination and be placed before the bench having determination.
Obliged, Your Lord. I appear for Election Commission.
All right.
But I don't know 329, the same issue is involved. One sub determination.
I'll release it.
Your Lordship.
329 which list?
Of today's list.
329. Ache. Motion.
নাম দিয়ে দিও তোমাদের আমি নেই
Oh, new motions. ঠিক আছে, released. Yes.
ওই তো তোমার ম্যাম বললো T29 আমার নাম দেবেন না আমি নেই না আমি তিনি আছি না
Lordship, I appear for the respondents in this matter. Lordship, this was dismissed for default yesterday. Upon his mentioning, I believe this matter was restored.
Yes. And the learned advocate couldn't find you because you did not file your wakalatnama.
No, Wakalatnama is already on there. Joyji Datta is the advocate on record. The CIS portal is showing that Wakalatnama has been filed.
This is what was submitted by the learned advocate for the petitioner yesterday. Anyway, yes, what is the matter?
Lordship, he has wrongly submitted.
Yes.
This is the release of previous due salary, my lord.
Release of dues.
Dues.
Where were you serving?
Lordship, this salary has been due from August 2023, read filed in 2025.
And kindly see the page 50.
But why is the salary due and why will it be kept due?
Petitioner is the medical unfit, my lord. He is totally handicapped. His legs are totally handicapped.
Yes.
He is unable to join the company, my lord. And page 50,
You have been on leave.
you have been on leave since 7th August 2024 due to your medical condition, my lord. This is to inform you that as per your medical examination report, the patient is treatable, but not treatable. I have filed all the medical documents to the department. Additionally, we require a written confirmation of your final date of returning of work. But in this letter, my reply is page 51, my lord. Next page. Page 51.
Yes.
Compliance.
1 minute. What is the date of page 50? 7th of August. Which year?
7th of August.
Which year?
Received on 7th of 2025.
25.
7th August 2025.
Where do I get 25?
Reply of 7th August 2025.
All right.
And my lord, second para.
Hmm.
As per your mail, it is understood that you are willing to know when myself joined to my duty. In this connection, it is stated that myself is in ill condition for severe knee pain.
Hmm.
Myself several times requested to you people that kindly release my pending salary, but neither get any answer nor my salary, salary and medical. In this connection, it is mentioned that you people stop my salary from 2 years ago, day by day. My knee condition is deteriorating and myself is unable to make treatment due to financial crunch condition.
Did you submit any application for
my lord?
Voluntary retirement
My lord.
or whatever? Where is it?
And in this application, my prayer is kindly information please, and it is further requested to please release my above mentioned all dues in the
How
earliest.
can your dues be released? Because you are not attending duty for the last 2 years. So you cannot expect the authority to pay you for not doing any work.
No, my lord,
Your
kindly
Lordship, not for last 2
page
years. He has not
56.
been attending duties from August 2023. That
My
is
lord,
One
incorrect.
minute, please
page,
wait.
page 56.
56.
Their reply
Yes.
for area dues, but it is written in his 7/8/2023 to 39/2023, 35 दिनों का computer अवकाश. This is the chart of
55 days. Oh no, 35 days.
and their answer. And
61 days to 51 days and 23 days.
My lord.
Yes, this was in 2024 calculation.
My lord.
The entire 25 you did not join. Today 26 we are in the end of April.
So my consider my application.
Where is your application? What is this web cost?
57, my lord.
What is this web cost?
Lordship, WAPCOS is the water and power consultancy services of the Government of India. It's a PSU, Government of India undertaking.
All right.
Lordship, all the most important documents they have not annexed. We have given them repeated letters that you kindly come and join the duties from 2023. He has not been attending duties. He has not given any reply to my letters. That what is the difficulty that you are facing in joining the duties? He's saying that I was operated with osteoarthritis in 2 of my knees. So that thereafter I said that you go and check up with a proper medical board. I am following the medical board. They have gone there. He has gone there, and the medical board has said that this disease is curable and he can join the duties after the operation. He has never been operated. He has never offered himself for operation. He has not taken any steps for joining the duties or curing his osteoarthritis.
Tell me one thing, what is the post in which he is serving?
Lordship, post. Let me tell you, Lordship, the post.
Senior assistant PNA.
Senior assistant PNA.
Yes, what is his work? He goes and sits over there, and is it table work, desk work? He has to move around. What is it?
No, he doesn't have to move around. It's a table work. He doesn't have to move around. Yes.
Is he the petitioner?
He is the petitioner.
It's perfectly all right. He can go and join duty. Why is he not going?
He is not willing to go there, my lord. He wants to release his area dues.
And without any work, you expect?
No, my lord, page 57.
Page 57, what is it? 2025, January 25.
Here is. My lord, page 58, last period. In view above, it is requested kindly release my dues, pending salary, medical bill, and approved VRS request at the earliest, please.
Approved VRS. Where is your application for VRS?
This is the application.
This is the application. Where is the application? I do not see any application.
There is no application for VRS, my lord, in our record. It's never applied.
My lord,
He has not been attending duties for the
so
last
many applications.
Show one. Show at least one. You should be ready with the papers and not the petitioner stand by your side to help you out.
Lordship, I will bring everything on record if your lordship allows me to file an affidavit in opposition. That nothing is, they have not made any application for VRS, not attending duties for the last 3 years, repeated representations not replied to. And today he wants, without doing any job, he wants his salaries to be released, medical benefits to be released. There are no document.
The petitioner was serving as senior assistant within bracket PNS of WAPCOS Limited, a Government of India undertaking under the Ministry of Jal Shakti. Stuff. He alleges that he is suffering from severe osteoarthritis and is not in a position to perform his duties. Stuff. It has been reported that the petitioner is absenting duties since 2023. Stop. According to the paragraph, according to the petitioner, he took the help of the medical consultant, but his physical condition has not improved. Stop. He is physically not fit to perform his duties. Stop. He intends to obtain voluntary retirement from the job. Stop. On a perusal, no. The petitioner has prayed for a direction upon the respondents to release all his dues so that he can retire voluntarily. Stop. Learned advocate representing the respondent submits upon instruction that the disease of the petitioner has been found to be curable. Stop. The petitioner has not forwarded any document in support of his medical treatment. Stop. The petitioner has been found to be unauthorizedly absenting himself from work. Stop. Paragraph. On a perusal of the documents annexed to the writ petition and upon hearing the submission made on behalf of both the parties, it appears that the petitioner has not filed any application seeking voluntary retirement. Stop. Without a proper application, it will not be possible for the employer to consider the prayer of the petitioner seeking voluntary retirement. Stop. Paragraph. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to make a comprehensive representation disclosing all his difficulties in attending work with the prayer that he intends to make. Stop. In the event any such representation is made, comma, the same shall be considered by the authority strictly in accordance with law. Stop. The authority may grant an opportunity of hearing to the petitioner to assess his physical condition. It will also be open for the authority to check the physical condition of the petitioner by a medical expert. Stop. A decision in response to the application made by the petitioner shall be taken within a period of 4 months from the date of filing the same. Writ petition disposed.
Careful.
Let's
Not this week, 19, 20, 21.
Twenty.
19, 20, 21.
Hey.
Petitioner is not here. Not this week.
But simply not this ignored.
23. 23.
Not this week.
24. 24.
26. Not for the petition.
Yes.
The case is that, my lord. Lord, the case is that I'm a petitioner. I'm not given pension.
You're not giving pension? Not getting pension? Why?
Lord, because 26.
Why are you not getting? Where were you serving?
My lord, I'm the wife.
You are the wife.
My name is not recorded in the PPO. My lord, a hearing has been taken place.
By whom?
My lord, the director of ration, Asansol.
All right.
My lord, he has recent order. My lord has been passed. Where my lord, it is written that I do not have the certificate.
Which certificate?
My lord,
Marriage certificate.
Yes, my lord. But I have the pictures.
Pictures? How you can take pictures with anybody?
No, my lord, I've been some long back. My lord, I did not.
Who is going to ascertain the date of the picture?
My lord, the ration card, my lord, Aadhaar card, my lord, even my lord, the legal age certificate.
Yes.
Even my lord, the Pradhan has been has given in writing that I'm the
Yes.
wife.
Right.
My lord, even after that, my lord, it has.
Is there any other claimant claiming to be the wife?
No, my lord.
No?
No.
Yes. Then?
Then, my lord, he has rejected my claim, my lord. Then I have sent a representation that has not been considered.
After rejection of your claim, is there any scope for further consideration? Once they say no, if you again go, will they change their stand and say yes? It won't.
Read court has, my lord, the ample power, my lord, to see, my lord, what at the my lord,
How will the writ court get to know as to who is the husband and who is the wife of somebody?
there's a perversity in the reason order, my lord.
Perversity in the reason order. All right. Then the writ court has to see. Who is your other side?
I don't see, my lord.
You don't see? Where is your affidavit of service? Who did you serve?
So I've served all the
All means?
all the respondents.
Did you serve the GP's office?
Yes, my lord.
Where is it? I do not see the GP service. Is it there?
My lord, yeah.
It is there. Find out from the GP office who has been engaged. All right. Give a call to him. In case the other side is there, I'll take it up today. And in case the other side is not there, I'll take it up next week.
My lord, wait.
All right. Come prepared. I'll hear you. Yes, next.
27. I don't know 27.
Not this week.
But 27. I was
You-
for the
Petitioner.
yes, my lord.
But then your other side is not here.
Yes, my lord.
Not this week in that case.
Not this week. Deeply obliged.
Item number.
And I'm appealing for the CISA.
Yeah, yes, sir.
Yes, ma'am.
The other side is not here.
Not this week.
Item number 29. Oh, 30. Item number 30. 31. Item number 32.
Not 32. I am for the private school 7, my lord. But I am suffering because my flat has been sealed, my lord. During pendency of this contempt application, I am, my lord, initially I am, my lord, running a consultancy firm. That is why, my your lordship direction was there.
32.
Yes, my lord, 32, my lord. But now, my lord, as per your lordship direction, we have vacated the flat, my lord, and we are not using the, my lord, for the said flat for my any commercial purpose. Now, I have also, my lord, prepared what supplementary review. Lordship allows me to file, my lord, I have, my lord.
Next day. Next day.
Yes, my lord.
Yes.
33.
The with Karat.
34. Item number 34.
Your Lordship, I am for the contender number 2. In this case, Mr. Amit Ranjan Pati was appearing. Due to election issues, he is not being able to present here. So kindly make it not today.
Election. What does election issue mean?
Voting issues, sorry.
He's gone for voting or is he
Yes.
contesting the
No,
election?
voting.
All right. I adjourn it.
Correctly.
35 item number.
35 mal. And for the contempt level.
The other side is not here.
36.
36 also.
ডাকতে থাকুন।
37.
37 also.
Are you taking steps?
Malad, we have taken step in respect of all matters. Malad, we have wrote to the state is required because we wrote to the state.
Police is not giving you
In one occasion, mainly in one of the matters, Malad, police came. We have conducted demolition the top floor of one of the properties. The rest.
How many
Malad,
floors are there?
Malad,
4, 5.
4, 7.
7 floors?
6, 7.
6, 7
Like,
floors.
yes. Malad, 6
And
floor.
completely unauthorized?
In Malad, one completely unauthorized, another Malad second story up to second
Just
story.
imagine 7 floors unauthorized. If it collapses, what is going to happen?
Malad,
And what were your
Malad,
engineers doing?
Malad, if your lordship kindly sees in pursuant to your lordship last direction, Malad, we have wrote to the Malad police authority. Malad, they have rendered as so far the Malad water supply line and electricity is concerned in respect of Malad one of the property Malad that could be executed. In respect of rest to Malad, that even could not. Malad,
Would not be done.
yes, Malad,
right?
that is not our part. So far the electricity is concerned, they are also unable to Malad cut the electricity because police assistance is required. And we have given a report, Malad, that police assistance is required. Malad.
Come back next week. Let us see what can be done. But then if the state police fails, I'll take the help
Malad,
of the
may I
central
propose
agency.
one thing, Malad, in respect of one of the matters, Malad, since Malad there is Malad MCC, Malad, they have taken a step, they have taken a plea, but since there is an MCC in operation, Malad, it is not possible. So
What is MCC?
Malad, Model Code of Conduct.
Oh, that is only for the elections.
Yes, Malad. So Malad, can we come after the election, Malad, not next week, Malad?
Next week, let us see what happens. I'll take it up.
Malad.
Next.
My lord, 38, sir. 38.
Yes, 38. Is your other side there?
No, my lord. We have served the as per
Keep
your
it with
direction.
you. Today, at least, I won't pass any order.
My lord, one indulgence, one. As I served the copy to the container, but they are avoiding the service, my lord. This is clear that they have left the office without instructions.
Left the office?
Without
Who is the
instructions.
contemner?
Chief Executive Engineer, my lord.
How can Chief Executive Engineer go?
That's why.
You keep it with you. I know how to handle these issues. Come next day.
My lord.
39 I am for the
39 I am for
my lord.
Durgapur Municipal Corporation led by Mr. Shantivan Banerjee.
My lord, the last
Mr.
occasion.
Banerjee engaging for election purpose and
election purpose? He's contesting.
Vote.
No, he go for casting vote in Durgapur.
All right, not today.
Lordship, item 32 and 33
Wait.
also.
Yes, call.
Lordship.
Lordship, I am for the petitioner, Lordship, in this matter.
I
am for the petitioner. Against the Lordship, Baruipur Municipality, Lordship. Kindly make it not to the Lordship.
All right, not today.
Lordship, item number 44, HON'BLE Municipal Corporation led by Mr. Shantivan.
For the contempt of municipality.
Has the order been complied?
Order tried to comply, but the building of the contempt, building of the respondent and the building of the petitioner are on the same ceiling. If it is broken, that building also be broken. Will be demolished. Have to be demolished. I have made a report, prepared a report to peruse your lordship.
All right, next day I'll take it.
Yes. 47.
Yes, 47.
আমি কর্পোরেশনের লয়ার আমাকে কিছু কাগজ দিয়েছিল ডিসপোজের দিন, আরো পরে কিছু কাগজ দিতে, সে একটা কাগজ কর্পোরেশন আমাকে দেয়নি।
কিন্তু উকিল বাবু তো আপনাকে কাগজ দিয়েছে
না,
বলছেন।
কোনো কাগজ দেয়নি।
আচ্ছা,
আমি পরে সার্টিফিকেট কপি যখন পাই নিয়েছি আগের কত বছর আগে, সেখানে দেখছি উকিল ওরা কর্পোরেশন মিথ্যে একটা স্টেটমেন্ট দিয়েছে, সেটা কিন্তু আমি পাইনি।
আপনি কি জল এখনো পাননি?
লর্ডশিপ জল আমি সঙ্গে সঙ্গে পেয়ে গেছি আপনার অর্ডারে। আপনি যদি আমাকে অর্ডার না দিতেন আমি সারা জীবন জল পেতাম না।
আচ্ছা, এবার কি চাই?
এবার আমার এই কন্টেম্পটের কেসটা পেন্ডিং।
Contempt. So if I may serve the alleged contempt, my lord, and
Now, who's stopping you from service? There is a direction, please serve.
there was no direction, my lord.
Is it appearing for the first time?
It appeared before that day. I did not appear, my lord, but there was
Let
no
me
private.
see, ফাইলটা আছে। আচ্ছা, কত 48?
48.
48. Check up in the server. What is the order? Is Shailesh is not there, na?
It had appeared, my lord, but that day I did not appear. That is why it was adjourned.
CPAN 1916. না না না, দেখতে হবে না, ইন্টারনেটে দেখে নিচ্ছে। None appears adjourned for the day. Notice. Notice. Who is the contemptor?
My lord, the Pradhan of the Gram Panchayat.
All right, serve. Yeah, it is returnable on June 25th. 14th June তো হবে না, 18th June last ছিল। 25th of June. 25th of June, serve.
I for the petitioner.
Petitioner,
Yes, me. I for the petition.
is it appearing for the first time?
No.
You've served it?
Yes.
Please, I'll adjourn it for the day. Next.
My lord, I'm for the petitioner, my lord. My lord, I have served him, my lord. My affidavit service ready, my lord. If lordship takes up, or otherwise, my lord.
Next day, I'll take it up.
My lord. Great.
54, 55, 56, 57, 58, 59.
59 for the petition, my lord. Pursuant to your lordship direction, I have served, my lord.
Next
My
day.
lord, as you lord.
53, 4, 5, 7.
67. Yeah, appear for the petitioner, my lord.
Is it appearing for the first time?
No, notice has been served, my lord.
Then come back next day.
My lord.
Okay.
First time?
The serve already service.
20, 21, 72, 73, 74, 75, 76, 77, 78.
Lord, I am for the petitioner.
Which one?
78.
Yes.
Soft copies on the other side, my lord. His affidavit of service to be kept.
This is an application for review
Yes, my lord.
of the order passed by this bench.
Yes, my lord.
But then the other side is not here. Arindam Das appearing in person. Please uplist the matter. 7th of May it will appear.
7. My lord, next week means 15th, my lord.
14th of May.
14th, my lord.
All right, 14th of May it will appear at the top. You please give one notice to your other side that it will. No, since I'm upgrading it.
29.
No, first time?
No.
No. All right. Next. Animesh Babu. যে মামলাটা $80.
82, my lord, I'm appearing for the petitioner, my lord. I'm going to let this matter retain its position, my lord, on the next day.
Yes, it will retain its position.
Much obliged, Judge.
84, 85, 86, 87, 88, 89, 90, 91.
87, not doing. 88. We're not appearing in these matters.
No, my lord, somebody else is appearing.
Contempt gone.
My lord, 163 to 67 I am appearing.
All right. Let us see. Yes.
89, 90, 91, 92, 93, 94.
24, I'm for the petition. Pursuant to your lordship direction, I serve upon the contempt.
I'll hear you on the next day.
95.
95, Lord, I appear for the
But I appear for the KMC lordship. Demolition order, why it is not completed, my lord, that was my lord's observation. Now, my lord, we also explain our inability why it is not done. Because
police was not available.
No, some police are occupied.
Police, Lord, we have filed the report.
And my lord, some newborn babies have also come in the meantime. Locality, my lord, stood in the way of what doing the demolition work. And whatever it is, my lord, we wanted that we shall comply, my lord, sort of subject to the area or the spaces, my lord, or the rooms are being vacated. So my lord was pleased to direct, my lord, the superintendent of police, not police, superintendent, my lord, the deputy commissioner of police, South Suburban local police and others to take the last order to take necessary steps so that we can comply, my lord's order. My lord, that is not yet, my lord, been done. So, my lord, the part which is not vacated as yet, that is because of this occupation. Some persons are occupying, and my lord, the sympathy is also being drawn from the locality. We are facing, my lord, this sort of problem, a similar seizures crisis from two end, humanitarian ground, and second, my lord.
So humanitarian grounds, the unauthorized construction should be retained.
We are ready to demolish.
You are ready to demolish.
Vacate it. Police was directed, you take necessary step to get it vacated.
The police is not doing anything.
That is not done as yet.
I don't have that instructions, Lord. Let a copy be.
Instruction?
Let a copy.
File anything? I have made my mind clear in a number of matters that I am going to engage some other agency if the state police is unable
My
to
lord,
take.
that's right. I'm not
All right.
instructions.
today.
Copy of the instructions be handed over to me. So
Exchange. Nothing will be given today. Nothing will be given today. Next.
a copy দাও
Being adjourned for lordship is also effectively
96.
একটা দাও কপি আমাকে
করতে দিনই তো
না আমাকে এটা দাও
Yes.
ইনস্ট্রাকশনটা আনতে পারবো কিন্তু অ্যালিগেশন করছো না পড়ে নেবার কিছু নেই, একটা কপি চাই কি, ওটা ইনস্ট্রাকশন আনতাম কোর্টে ফর অ্যাসিস্টিং দি কোর্ট।
Hmm.
106, 107, 108. But for the petition, 108. Lord, no. Compliance report was Lord called for. Contempt appeared, Lord. He has paid for Lord time. Lord, case was adjourned. Lord, thereafter, Lord, no progress.
Come on, the next day I'll hear you.
For the petition, Lord, first time application.
Which one? 113?
Yes, Lord.
It's appearing for the first time. There was no deduction earlier. All right, deduction is being passed. You please solve. All right. And it is made returnable on the 25th of June. Give your appearance.
I am for the petitioner. Copy is served upon the contemptor on solemn rejection of honorable court.
I'll hear you on the next day.
On next Thursday.
Yes.
121, 122.
I am for the petition.
Other side? First time?
Review application. This is a review application.
Oh, this is a review. Did you serve?
Yes, sir. Already served.
All right, next day I'll take it.
23, I appear for the petitioner. This is the second time.
That means already served. Wait, next day.
126, Honorable Corporation.
All right, next day.
128. 129. 130. 131.
31 my lord, I'm for the petition. I have served my lord. 31.
Next day.
140. 104. 105. 136. 137. 138.
Lordship, 138, Honorable Corporation, led by Mr. Shantanu Banerjee. 41 also Honorable Corporation. 45 also Honorable Corporation.
My lord, I am for the petitioner, my lord. 161.
Is it appearing for the first time?
No, my lord.
Then come back next day.
We're at 62, Lord. Nobody is there. 62?
Yeah. My lord, I am for the petitioner.
First time?
No. My lord, 18th of September, your lordship was pleased to direct the municipality and the municipal affairs, my lord, to settle the matter, my lord, how they will pay the petitioner. 2014 claim. Each and every day's violation. Till now, nothing has been done. My lord, I am paying for upgradation.
No, upgradation cannot be done because that will amount to adverse order to your other side, which you all have taken a resolution not to pass. All right.
Then kindly fix a date, I will communicate.
Do not communicate. It is there in the list. It will remain in the list.
My lord.
Yes, next.
Let 163 to 67 say.
All right. Call 168.
My
Lord, I appear for the respondent bank.
All right. Next day.
171. 172.
Is this matter which was there in the Supreme Court? And
Yes, my lord, they have it's fixed tomorrow, my lord. It matter is fixed tomorrow. And
Alright,
my lord, I my lord, did not get the guarantee, my lord, of VTL, my lord. Indemnity of VTL, my lord. That
Very well.
very well. Lord, you will hear me on that.
Well, 177, I was appearing for the.
One
I was
second,
appearing.
Lordship, I am for Hon'ble Corporation led by Mr. Shantipan Banerjee.
177 is not against Howrah Municipal Corporation. This is
What's
against
it?
the registry of companies. 177.
All right, your other side is not here.
Very good. I'll come back next week, my lord.
Please.
Grateful.
Hmm. Yes.
180, my lord, I appear for the stay. But my lord, it is related
Yes.
to my lord, the tender PWD.
It's a contempt matter. Yes, next. Hmm.
185, my lord, I am for the alleged contempt. My lord's order has been complied.
Complied?
Yes.
Is it communicated to your
Yes,
other
yes.
side?
Because
Next Thursday at the top.
because they have received.
Please intimate your other side.
My lord, that has been already, my lord, my client has already served them.
No, but then if you can give notice, then I can dispose of the matter.
Yes, yes, that I can intimate.
Give notice
To the other side,
to the other side next Thursday
next Thursday.
at the top to be mentioned.
My lord, because order has been complied.
All right.
And we have already,
Well,
direction has been given also.
185.
185.
185. Next Thursday at the top.
186.
Yes.
187. 188. 189. 190. 191. 192. 193. 194. 105. 106. 107. 108. 109. 200. 101.
Other side is there.
Not
Next.
102. 103. 104. 105. I'm for the alleged contempt, my lord.
Order not complied.
In the verge of completion.
27, 28, 29.
29, lordship, we have complied my lord's order. Yes.
Complied?
Yes. And affidavit of compliance is also made ready. And they are not also willing to proceed with the matter. They have given the letter also to us.
All right, next Thursday it will appear at the top. All right. 209, please intimate your other sides next Thursday
Phone also, they are always ready to cooperate with us.
at the
However, I
top
will.
to be mentioned.
Lordship.
All right, next.
Grateful.
111, 112, 116, 117, 118,
My lord, on behalf of the petitioner, my lord, it's a restoration application, 290.
Your other side is not here. Next.
No, this is the first time, my lord.
All right, serve notice.
My lord, return again.
It's 25th of June.
Grateful.
25th June.
Lordship 225, Hon'ble Corporation led by Mr. Shantipan Banerjee.
No, 26.
Next call.
Well, I'm for the petitioner.
Yes.
Paying on a family pension was not paid. My daughter is going to stop the studies. But
Wait, this is appearing for the first time.
we shall have let it appear in the month of May, my lord. My lord, family pension was due in February 2026. Family pension. My lord, kindly fix in the month of May. I shall serve today. It is Birbhum.
14th of May.
I'm grateful, man. First time, 14th May.
Yes.
I'm grateful, man. Sure.
ডাকতে হবে না বাবু Would you like to mention something?
No, my lord. My lord, item number 136, we are for the alleged contempt. So can I file the affidavit of service?
If contemptor will be filing affidavit of service.
Compliance, my lord, compliance.
Please come on the next day. Did you serve copy upon your other side?
No,
Please serve. I'll take it up on the next day.
My lord,
Item number 113, my lord, I have wrongly submitted.
260.
I have served.
Eight.
On the previous occasion, directed my lord to serve, my lord, I have served. My lord, wrongly, my lord, I have submitted.
হবে না, ওটা তো উপর দিকে রয়েছে, কি করে ফার্স্ট টাইম হয়?
My lord, may I?
Yes.
My lord, with regards to item number 268, my lord, it is
Yes.
new motion, my lord. The petitioner is very poor, my lord, getting only 5,000 rupees per month, my lord. Have
Yes.
challenged an order, my lord, if it can be taken up in any date, my lord.
Challenged an order means what order have you
My
challenged?
lord, my lord, this is second time. First time, my lord, the honorable court directed to consider, and they say, my lord, even we are working in the regulated market committee, the board say, my lord, we are not the workers of the market committee since we have been deployed from the role of, my lord, district magistrate. We are not the worker. The market committee is deducting provident from us, from our, my lord, 5,000 and odd salary. My lord, this is, my lord, the fact. Only 5,000 less, more or less, we are getting.
Item 268.
268, my lord.
All right. Urgent motion next Monday. Serve notice upon your other
Yeah,
side.
yes, my lord.
Lordship,
Grateful,
item
my
number
lord.
128, Lordship of the monthly list. Lordship, there was a direction to serve the contempt application. We have served that. Lordship, may
128 of the monthly list.
Lordship.
Monthly list contempt matters.
Daily list, Lordship. I'm sorry.
Yes.
Of the daily list, Lordship, contempt matter. It was called up, Lordship. I was just coming and I.
All right. I'll take it up on the next day. I've dismissed your matter.
Lordship, may it be kept in under the head to be mentioned, Lordship.
Why?
Lordship, it is pending since 2025, Lordship.
There are other matters pending prior there too.
Lordship, some precedents may be given.
Why?
Lordship, this is the order has to be passed by the district magistrate. It is pending from long.
Yes. Come on the next day.
Lordship,
may I? 292 in the Delhi list, the new motion, because my client is suffering so much because compulsory appointment ground has been rejected.
Compassionate appointment?
Yes, 2019. And from this is also suffering a lot.
292?
Yes, ma'am.
Yep.
Yes,
Punjab National Bank?
Yes.
292 Monday served notice.
Lordship, may I please, your Lordship?
Yes.
Regarding item number 278, Lordship, there is a matter relating to withheld candidate, Lordship, under the
Which item?
278, Lordship.
278.
Kindly fix this matter on Monday under the heading adjourned motion, Lordship.
278 urgent motion. Monday serve notice upon your other side.
Grateful.
My lord, for the item number 242, my lord, direction was for a supplementary affidavit if it can be taken on record, my lord, only.
242?
Yes, my lord.
Yes.
My lord, direction was for the filing of supplementary affidavit if it can be taken on record, my lord.
No, there are other matters on top. It cannot be done. All right. That will be violation of Article 14, discrimination.